The legal treatment of vessels and offshore installation under the Mexican Foreign Investment and Navigation Frameworks. Under Mexican law, as a general rule, coastal trade in Mexican waters is reserved to Mexican ship owners with Mexican vessels or naval artifacts. Although this rule may be justified as a matter of reciprocity with neighboring countries, the truth is that it poses a major problem for Pemex, the Mexican national oil company. Pemex requires the services of hundreds of vessels and naval artifacts on a daily basis in the Gulf of Mexico, and Mexican flagged or owned vessel and naval artifact alone cannot cope with that demand. Therefore, in this article we will try and explain the available exception to that rule with regard to vessel, offshore installation, and those offshore craft that may or may not be deemed as vessel, such as semi-submersible rig, accommodation barges, drill ship, and floating production, storage, and offloading unit. Navigation consideration, cabotage permit. The Navigation and Maritime Trade Law, which entered in 2006, provides that if there are no Mexican flagged vessels available, foreign flagged vessels and naval artifacts may engage in cabotage trade in Mexico under temporary navigation permit. Cabotage is defined as the navigation between two ports of sport within the Mexican maritime zone. However, such type of permit doesn't grant much certainty to their holders in the long run, as they are granted for 3 months period and can be only renewed 7 times, a maximum total of 2 years. If a similar Mexican vessel or naval artifact become available right before a foreign flagged or owned vessel or artifact is to renew its temporary navigation permit, that permit shall not be renewed. Once the maximum number of renewals has been reached, the relevant vessel or naval artifact must be flagged Mexican in order to continue operating in Mexican waters. Only Mexican individuals and companies may flag and register vessel and naval artifact in Mexico, and this is provided they are owned by them or in their legal possession under a financial lease agreement. A charter party or lease agreement would not be sufficient. Foreign companies and individuals may incorporate a Mexican shipping company, but that company would be subject to the foreign investment restriction explained. Due to the aforementioned reason, owners of naval artifacts would normally opt for applying for a stay authorization instead of a cabotage permit. Stay authorization may be renewed an unlimited number of times, and their holders are not subject to foreign investment restriction. We will explain below who may apply for the so-called stay authorization. Applicants should also bear in mind the priority ranking for the granting of cabotage permit. Mexican ship owners with foreign vessel or naval artifact under a bareboat charter, in this case the whole crew must be Mexican, rank first, followed by Mexican ship owners with foreign vessels or naval artifact under any other type of charter agreement. In this case, priority is given to the vessel having a higher number of Mexican crew members, while foreign ship owners with foreign vessel or naval artifact rank last. Following an amparo proceeding initiated by Pemex, the Supreme Court decided in 2008 that the procedure laid down in the Navigation and Maritime Trade Law by which foreign companies may request and obtain cabotage permit doesn't contravene the Mexican Constitution. In their constitutional review petition, Pemex argued that giving preference to Mexican ship owners with chartered foreign vessels contravene constitutional principles such as equality, legal certainty, freedom of employment and commerce, and best value for money in public procurement procedures. Yet, the Supreme Court found that the fact that Mexican shipping companies are preferred over foreign ones doesn't create a monopoly, doesn't favor certain companies, and doesn't have negative repercussion on the general public or a social class. But on the opposite, it promotes national maritime activities, protects the national shipbuilding industry, and consequently benefit the Mexican economy. It must be noted that the aforementioned 2-year obligation to flag doesn't apply to highly specialized vessels or naval artifacts. For such craft, the NMTL doesn't set forth a limit on the number of times they may be renewed. The Supreme Court held in 2012 that the categorization of a vessel or a naval artifact as highly specialized shall have a 2-year minimum duration. Such categorization may be requested at any time when the first cabotage permit is requested or when the seventh renewal is requested. The NMTL provides that vessels and/or naval artifacts will be considered as highly specialized for their technology and services provided, crew requiring and particularly specialized training, or if they are highly specialized or not likely to be replaced by conventional technology, such as those used in the exploration, drilling, and early production of hydrocarbon. So, for the matter of whether a vessel or naval artifact is highly specialized is determined on a case-by-the-case basis. According to the draft regulation to the NMTL under revision since 2007, the following criteria would likely to be used in the future to determine if a vessel is highly specialized: her state of technology in the international market, the availability of her technology in the international market, and construction and equipment report in respect of vessels and naval artifacts that may be considered as extraordinary. Some vessels enabled with the Level 2 dynamic positioning system have been regarded as highly specialized vessels for the purposes of temporary navigation permit. However, this is not necessarily a factor to be taken into account to categorize a given vessel as highly specialized. Lastly, another exception to the cabotage rule is the operation and management in Mexican maritime zone of dredges, as well as tourism, sport, and leisure vessels, which may be carried out by foreign ship owners or operators with foreign vessels or naval artifact, provided there is reciprocity with the relevant country. Stay authorization. According to Article 9 of the NMTL, vessels and naval artifacts are subject to an identical regulatory regime. Despite that, important differences may actually apply from a civil liability, tax, navigation, or a foreign investment standpoint. For the purposes of this article, we will only focus on the latter two.